Okay, good afternoon, ladies and gentlemen, and welcome to the last panel session on the cross-border legal harmonisation conference today. I'm Stefan Lowe, and I'll be the moderator for our session this afternoon, which is on cross-border insolvency. So Hong Kong does not yet have a comprehensive statutory scheme dealing with cross-border insolvency, but a major development last year between Mainland and Hong Kong was the implementation of the new cooperation mechanism between Hong Kong court and Mainland courts, and that is intended to facilitate recognition of mutual recognition between the insolvency office holders from both jurisdictions. So some of our speakers today will talk about that, as well as some other important aspects of cross-border insolvency. So we have a number of distinguished speakers on our panel this session. Before we start on the presentations, I'll briefly introduce our speakers to you. We have today Professor Bob Wessels, who will be speaking to us via Zoom from the Netherlands. Professor Wessels was formerly Professor of International Insolvency Law at the University of Leiden. Amongst other roles, Professor Wessels has been an independent expert counsel to the European Commission on Restructuring and Insolvency Law, and also chairman of the Independent European Think Tank Conference of European Restructuring and Insolvency Law. We also have the pleasure of Judge Dr. Min Kyung Kim from South Korea. Judge Kim is from the Daejeon District Court in South Korea. She has expertise in cross-border disputes, including cross-border insolvency. She has sat in the Special Division for International Commercial Cases at the Seoul Central District Court. Our third speaker will be Mr. Luk Chan Ho, barrister at Devo Chambers. Mr. Ho has over 2 decades of experience in company, commercial and financial law. He's practiced extensively in the area of restructuring and insolvency, and has also published widely on insolvency and conflict of laws. Finally, we have Professor Charles Booth. Professor Booth is the Michael J. Mark Distinguished Professor in Business Law at the University of Hawaii. He's the founding director of the Institute of Asian Pacific Business Law, a fellow in the American College of Bankruptcy, and a founding member of the International Insolvency Institute. And Professor Booth has published extensively in insolvency law in many jurisdictions, including Hong Kong. So we'll have our 4 speakers provide their talks first, and then we'll have a general Q&A session afterwards. I'll now invite our first speaker, Professor Bob Wessels, to give his presentation. Professor Wessels' talk is titled Cross-Border Insolvency Between Mainland China and Hong Kong, Challenges and Opportunities.
Hi, good morning, everyone. Thank you for inviting me via modern technology. Just to give you an impression, in the Netherlands presently, it's around 10 degrees Celsius, which we call the beginning of winter. And luckily, the organizers and I found out that 4 days ago, Europe is on winter time. Therefore, I could be connected to you. I recall that my first flight to Hong Kong directly from KLM Amsterdam, of course, took around 9 hours, but was in 1992. And at that time, I remember there were not flights allowed to go directly to either Shanghai or Beijing, and you had to fly either via KL or Hong Kong. I had hoped to celebrate my first coming by airplane to Hong Kong 30 years ago, but it wasn't possible, and I'm sorry to say so if I saw you just walking around in the break with all the you call it mouth caps. It's maybe it's better that this Dutchman, who is in an age of being at risk, I'm 73, that he won't come to Hong Kong. But intellectually, my dear friends, I am with you. Next slide, please. It's 25 years of basic law, and especially Article 95 is of most importance. The Hong Kong Special Administration Region may, through consultations and in accordance with the law, maintain juridical relations with the judicial organs or other parts of the country and may render assistance to each other. Next slide, please. So on that, most probably, you know, I'm just a foreigner looking in, most probably that has been the sort of constitutional basis for what Mr. Stefan Low just introduced, the rules of 2021, which for ease of reference, I call the 2021 arrangement. And I studied together with Dr. Shuai Guo. Shuai is presently an assistant professor at this China university, but he used to work in Leiden, the Netherlands, for 4 years, working on his PhD, which he defended, I think, some 3 years ago, on the recognition of judgments and other resolutions coming from banks. So he's typically a guy from the banks. Well, this is the arrangement. There's a record of meeting of the Supreme Court of China, together with the government of Hong Kong. There are under two some procedures, and there's the opinion of the Supreme Court on taking forward a pilot measure in relation to recognition and assistance to bankruptcy or insolvency. Next slide, please. I'm going to show you these very old books from, I think it's end of the 18th century, beginning of the 19th century, as an introduction to my own country. Next slide, please. Because Stefan Low, the chairman, just said Hong Kong is looking for, you know, a better way of cross-border cooperation. Well, my dear friends, the Netherlands work still with a National Bankruptcy Act of 1896. Did he say 1896? Yes, 1896. And there is only 1 or 2 provisions in the Dutch Act, and we don't have any full-fledged or even semi-full-fledged regulation with regard to insolvency, international insolvency law. And we get large cases. Yukos Oil from Russia, it lasted some 12 or 14 years. There was no legislation, so there was a hassle. But I think there are some 50 procedures, not only about recognition, but all other issues in the Netherlands. And all the judges are trying to do their best. The same was for the largest Brazil national landline telecom company and the air carrier Jet Airways in India. So what does this mean for practice? There's always uncertainty for the judges, but also for what I've done for a long time, how to advise parties that are looking for certainty. There are a lot of costs for legal opinions, for procedures to clarify what is happening in the Netherlands, or clarify court cases. Additional costs for parallel proceedings. If there are assets in the Netherlands, you can start parallel proceedings, parallel to proceedings pending elsewhere. And if there's any case law, is it also adequate to deal with this ongoing trend, especially also in Europe, of having restructuring that are based on imminent insolvency or the danger of becoming insolvency, only not pre-insolvency, many times based on negotiations, leading to what's called also the Dutch scheme. And of course, with all those costs, small businesses are not helped anyway, because you have to always have on board legal advice. Next slide, please. I had to say I'm advising also the Dutch ministry already since, well, 15 or so years. And many times I say to the minister, this gives image problems for you. We think that the Netherlands is seen as a rather open economy and rather modern, etc. Strange language though, funny people though, very direct in their communication, but nevertheless. But the legislator is seen as non-competent in this area. The whole legal framework is just weak. Our politicians, we've got around 16 or 18 political parties in the Netherlands. If you ask about insolvency, let alone cross-border insolvency, it's not on their top 10 list. So if you are looking for legislation, you have to make a large case of giving it priority. Where business is a part of a global community, you cannot stay on this level of providing legal facilities to solve insolvency-related business problems. And what politicians always say, and I know it is for mainland China in some 30 or 35, general treaties and conventions that are there, there's always the idea of reciprocity. Meaning we as a country assist the Netherlands if the Netherlands would also assist us in the same type of problems. We will later say a few words about the model law of UNCITRAL on cross-border insolvency, which is a grand example and has been enacted in roughly about 50 states, including a few years ago also for a large part in Singapore. But many of the states also apply reciprocity provisions. Before Mexico, for instance, will recognize a proceeding, it will check whether the country where the proceeding comes from, the Netherlands, for instance, always provides the same assistance. I always wonder, what's a justification? For me, it's typically public law idea between states, and states should, what's the justification for states to look for reciprocity? Next slide, please. So if you look at the 2021 arrangement, just pick up a few things. If you have an insolvent debtor, you must have a court that has international jurisdiction. And the opinion of the Supreme Court says the international jurisdiction is generally the place of incorporation of the debtor, which is the registration place of the debtor, and the court shall consider other facts. And in the English translation, we found the principal office, the principal place of business, the place of principal assets, and also between brackets, etc. Well, that is just something like, let's take all the things that are there and leave it to the judge to decide, and the judge has no common reference to deal with it. The general definition of international insolvency and the center of main interest, COMI, of a debtor is also whether the actions and the administrations being done by the debtor is ascertainable by third parties. And we don't find that element in the arrangement. So it is rather typically corporate law focused and not so much on the contact with creditors focus, which you see in nearly all jurisdictions applying the COMI definition. The possibility of having a parallel proceeding in the other place where it's not the international jurisdiction, let's say it is in one of the three, I think you call them provinces in China, and if there are operational activities of a certain extent, can you start secondary or non-main proceedings in that country? I don't know what has happened there. Which law applies if you have a proceeding with, let's say, a COMI in Hong Kong that has operational activities and contracts with mainland China? Which law applies? Is it a law that has been chosen by the parties, or is it another law? So there are applicable law provisions missing. Also, the model law on cross-border insolvency law doesn't provide rules for applicable law. Next slide, please. And then there's typically the public policy exception, which is rather common all over the world. Meaning, if there's an insolvency proceeding coming from the Netherlands, and it will be automatically under the EU insolvency regulation recognized in one of the other 26 or 7 countries in the EU, for instance, in Italy, Italy can say, we will not recognize it because it brings effects, or the proceeding itself is against public policy, or manifestly against public policy, which gives a larger discretion for a court not to provide recognition. But this is a very wide public policy definition. It's not only the basic principles of law of the mainland are violated, and I don't know whether there's a booklet with all those basic principles, but nevertheless, it's the word that's presented, or the public order and good morals are fair. And also, when the COMI of the debtor is not in Hong Kong, in the case of Article 2, when their mainland creditors not treated equally, when there's fraud and all other circumstances in which the People's Court consider that recognition or assistance should not be rendered. Okay, well, that brings in, it's not only what the Dutch call the goat part, the very small, no, it's a very wide field that the other country, in this case, China, can say, mainland China can say, it's against public policy. The next slide. Thank you. And the last slide, just pick some elements from the arrangement. Administrators, it says, in the 2 jurisdictions, should strengthen the communication cooperation in courts in the pilot areas in the mainland, shall actively communicate and take forward cooperation with the courts. Okay, thank you. That's all. You know, it's very open, abstract. Oh, the slide says it's a very abstract rule. If you compare to Article 27 of the model law, which has roughly the same provision between the 27 member states under the European Insolvency Regulation. And the forms of cooperation are, for instance, the appointment of a person or a body to act at the direction of the court, communications, coordination of the administration supervision of the debtors, assets and affairs. Why don't we agree in a sort of protocol concerning the coordination of those proceedings? And for instance, under F27F, the enacting state, which follows in its national legal text this model law example, may wish to list additional forms of examples of cooperation. Next slide. So without, you know, I've been 10 times in Hong Kong and China, just fly in and out. So, you know, this is typically a foreigner, but I'm trying to use my imagination. What should be the step forward? I think there are 5 avenues to at least take a first step, because this is in development. This is open for discussion. This is open for finding better ideas that can be used in the arrangement or as a new arrangement. And the elements I'd like to say are, you can learn from other mixed legal systems, improve the alignment with the UNCITRAL soft law, model law proposals, create an own system, create a separate regime for smaller companies, and develop a hybrid framework. And I will explain that later. Next slide, please. The first is that, you know, in the books, the one country, two systems idea is seen as a mixed legal system. So I thought, can we also learn from other countries that are using mixed systems in several ways of being mixed, because they don't understand each other's languages, or the country itself just merged from 2 other countries now into one country, or it is, I think, like Malta, partly Maltese national law with a large chunk of basic UK law. South Africa, my dear friends, I just wrote a book a year ago about the bankruptcy of Rembrandt that was based on Amsterdam city law of the 17th century, city law with regard to insolvency. That law is the basis for the application in South Africa. Okay, so you can, I think, if you dive into mixed legal system, especially in a group of students, there may rise the possibility of 2 or 3 elements on procedures, on substantial law, on communication, you name it, that you can use. Next slide, please. The proposal itself, the alignment, should better align with the key concepts of the model law: international jurisdiction, public policy, cooperation, because then people like me better understand what you can do within Hong Kong, China. I'm not going into the possibility that there will also be not a third country, but that it has a wider application. I think Article 96 of the Basic Law provides some sort of a basis. But in the present situation, improve the alignment with the UNCITRAL model law, and also learn, for instance, what Australia and recently Brazil have learned from enacting the model law. By the way, the thing is 25 years old, so you'd like to have some new elements in it. And I think that's Luc Jan Ho has written compiled a very good study on it from, I think, some 3 or 4 years ago, as a first start to look at. And consider also the new model laws on judicial decisions in the context of insolvency and on enterprise group. And maybe you've seen that in July 2022 in the UK, a consultation has started and maybe already ended, whether England, that has incorporated a large similarity of the model law of 1997, that England now is consulting, especially practice, shall we also consider the other 2 model laws? Next slide, please. Then a more structural approach. Xing Yi Gong has been my PhD author, I think between 2012-ish and 2016. And she wrote her book on the China inter-regional cross-border insolvency arrangement. So she proposes, and I'm basing my idea on her proposal, of course she is my doctoral candidate, on creating a more structural, permanent standing framework, including a judicial committee or forum or court to decide on matters. Next slide, please. Such an element would fit in this Article 27F of the model law, and it could base itself on the American Law Institute and the International Insolvency Institute global principles for cross-border communication in insolvency cases. And as Professor Booth knows, that was written by our late friend, Professor Ian Fletcher from London, and by myself. And I'm not an ambassador or a reverend, but it's still worthwhile to look at those principles for the overriding objective, for the better definition of international jurisdiction, recognition, relief, limited idea of public policy, how to formulate a stay or a moratorium, the use of protocols, but also in an arrangement, a standing judicial committee, the dispute settlement committee between mainland and Hong Kong, an interregional case register where these international cases are deposited, and also the possibility of using independent intermediaries, which is a possibility also. Next slide. So I said 5 avenues. This is the 4th one. Why should we bother small companies with all this very detailed formal judicial rules? I think a definition for an SME you can find in a recent study from the the Asian Business Law Institute. I think the study was from April, and I think there's also a definition of what in your, let's say, culture, including China, is a viable debtor or an enterprise to being a small enterprise. And I'm just referring to this dear bilateral treaty of 1925 between the Netherlands and Belgium. Belgium is a different country. Yes, my dear friends, it's a different country. We used to be together, but since 1838, these are 2 countries, and a small part of the country speaks some Wallon, which is a French version, and the northern part of Belgium speaks sort of Dutch. It is Dutch Flemish. But there is automatic recognition. So why don't you have automatic recognition for smaller companies? Unless, and just the 4 rules, also item 1, public policy, that it can be enforced in the other country, but also section 4, that the parties have been lawfully presented so that you know that it is. So there are bilateral treaties from narrowing countries who are neighbor of each other, who many times have economic ties across the border, and you should facilitate that, I think, much more easier, for instance, than the Netherlands that would work together with Venezuela, because there are only incidental economic relations. And the last one, last slide, please. Thank you. A hybrid framework. Hybrid framework meaning you have some sort of a structural kikia. I used to say it, the China regional cross-border insolvency arrangement, plus an agreement. And the agreement deals with a targeted approach. The case is upcoming, you know it is there. Why don't you write in a few days a protocol only for this specific case? And the instruments, basic instruments, are in the KIKIA, but also already some sort of an idea of a model or a basic draft of a protocol. And then you can get inspiration of protocols that have been, model protocols have been published. I think it was last year. I think I refer to my blog where you find some materials. So you focus on case specific circumstances and need, and you arrange for an individual cooperation. Maybe appoint an independent intermediary, maybe appoint an information officer like that has been done in still in Canada, or a mediator. But my idea for today was, and that's my final remark, the present system needs, coming from the best European advice, needs improvement. If you want to go on the way of further cooperation, which gives certainty, which is what many businesses want. And then there are 5 ways to feed the new arrangement of it's now 2022, 2023. Doesn't have to take too long. Thank you very much.
Okay, thank you, Professor Vessel. I now invite Judge Dr. Min Kyung Kim to provide her talk on cross-border insolvency in the Korean courts, introduction of the Hanjin Shipping Insolvency Council.
Good afternoon. It is an honor and pleasure to be here or to be able to speak at this distinguished event. Today, as a sitting judge in the Korean judiciary, I would like to share my knowledge in the area of cross-border insolvency. I would like to introduce the Hanjin shipping case, one of the most high-profile insolvency cases to date in Korea. I'd like to share what we learned from the case, but before I delve into the details, let me briefly outline how insolvency law works in Korea. The court-led insolvency proceedings in Korea can be divided roughly into 2 categories. Rehabilitation, which corresponds to the Chapter 11 procedure of the US Bankruptcy Code, and bankruptcy, which is similar to Chapter 7 proceedings of the US Code. And both are covered in the Debtor Rehabilitation and Bankruptcy Act, which I refer to as the DRBA. The DRBA adopted the ancestral model law on cross-border insolvency and is thus based on the principle of universality. It means that the foreign proceedings will be recognized on the specific requirements. Foreign creditors can participate in the Korean proceedings and are treated equally to domestic creditors. However, the DRBA deviated from the model law on particular points. The key differences are that 1, the Korean Act did not adopt the concept of main and non-main proceedings, and 2, that the recognition of the foreign proceedings does not entail an automatic stay order on the debtor's assets. The recognition order only confirms that the foreign proceedings are eligible for the Korean court's assistance, such as stay order or other reliefs. In this regard, the recognition order can be referred to as an admission ticket. Chapter 5 of the DRBA covers various aspects of cross-border insolvency. It provides, inter alia, that the Korean insolvency representative can seek recognition in a foreign court or participate in foreign proceedings, and the Korean court can cooperate with foreign insolvency courts regarding parallel proceedings. I would like to address how these two unfolded in the Hanjin case. Hanjin Shipping had been ranked 9th worldwide and 1st in Korea in the shipping business. It operated 144 ships with more than 60 regular lines. But due to the global financial crisis in 2008, the demand for shipping fell, leading to reduced prices. And 2015 saw a dramatic fall in fares due to the increasing supply of ships. In June 2016, Hanjin's balance sheet showed $5.6 billion in assets, $5 billion in debts, and recorded a net loss of $315 million. In August 2016, Hanjin applied for the commencement of rehabilitation, and the court issued a stay order regarding its assets. And the next day, the court granted the commencement order of rehabilitation proceedings, which was rendered in an unusually short period of time. However, after 5 months, the rehabilitation proceedings were converted to bankruptcy proceedings, in which the bankruptcy of Hanjin was subsequently declared. Several factors made Hanjin's rehabilitation more difficult. First, Hanjin operated with container carriers with regular lines. And this type of business has more customers than bulker carriers and allows less flexibility in revoking existing contracts. Furthermore, Hanjin had sold its core business assets, such as the regular line to the US, Long Beach terminal, and its American subsidiaries. Secondly, most of their ships were technically not owned by Hanjin, but bareboat chartered hire purchase, in short BBCHP. I will return to this later, but stay orders in Korea are only granted to debtors' assets. Therefore, their BBCHP ships were exposed to ship arrests. In addition, a few of Hanjin's leading destinations, including the PRC, Egypt, and Panama's law, do not recognize the Korean insolvency proceeding, causing an even greater risk of ship arrests. Thirdly, although Hanjin was a subsidiary of Korean Air, it could not expect financial aid from the parent company. And this was because lending money to a subsidiary in need would be against the director's fiduciary duties to the parent company, which has criminal law implications. Now, I will turn to the cross-border aspect of this case. As Hanjin ships were traveled worldwide and had assets all around the world, cooperation with foreign courts was essential. The Korean insolvency proceedings were recognized in many different jurisdictions, such as the US, Australia, the UK, Germany, Singapore, Japan, and etc. In other jurisdictions, including the PRC, Hanjin did not apply for a recognition order in the first place, as it was advised not to do so due to a low prospect of success. In Hanjin's case, the Korean court set out an excellent precedent in terms of judicial cooperation. The US New Jersey Bankruptcy Court recognized the Korean proceedings and allowed the proceeds from the sale of Hanjin's US assets to be repatriated to Korea. And this was actioned through the court-to-court communication. The New Jersey court also granted an extensive stay order, including the BBCHP ships, despite the objection brought by bunker suppliers who were maritime lien holders. The New Jersey court found that although Hanjin did not own the BBCHP boats, in order to achieve the practical objective of moving cargo from Hanjin's vessels to intended destinations in the US, it was necessary to extend the stay order to vessels chartered to Hanjin. And this logic led to stay orders on the BVCHP ships in the UK, Germany, Singapore, and Australia. However, under Korean law, only the debtor's assets are subject to stay orders. And whether the court should grant a stay order on the BVCHP ships boils down to the question of who owns the BVCHP ship. As I mentioned, BVCHP means bareboat charter with a hire purchase agreement by which the ship shall acquire the nationality of the charterer upon the expiry of the charter period. As shown on the slide, BVCHP ships are owned by the SPC, but the charterer, in the present case Hanjin, was to acquire the ownership upon paying full charterage. So there are conflicting views how to tackle this question. The prevailing view is that the SPC owns the BVCHP boat, focusing on the fact that the ship is still registered under the SPC and it can repossess the vessel in case of default. Others say that the BVCHP is akin to finance leases, so the charterer should be deemed the owner and the SPC as a secured creditor. A district court in Korea took the former view. In this case, maritime lien holders who were bunker suppliers to Hanjin applied for the auction of one of the BVCHP ships, and the application was granted. The court rejected the Hanjin's contention that the ship was owned by Hanjin, so the stay order should be extended to the boat. And this, of course, had a negative effect on Hanjin's rehabilitation. And this decision still remains controversial in Korea. And this is a question of how to balance conflicting interests between the debtor's rehabilitation and the rights of secured creditors. In my opinion, there are a few lessons to be learned from this case. First, Hanjin's insolvency was not a prepackaged plan. It took only 1 day from applying for rehabilitation to obtain the commencement order. And once the procedure commenced, the debtor could not withdraw from the proceeding. And this did not allow Hanjin and the Korean government enough time to deal with the subsequent logistic disruption in the market. In this regard, in the aftermath of Hanjin's case, the Seoul Bankruptcy Court adopted a new procedural rules, providing debtor with sufficient time to consider a voluntary workout plan before the commencement order. Secondly, Hanjin case showed the importance and effectiveness of judicial cooperation, especially in cross-border insolvency cases. The Seoul Bankruptcy Court is making its best efforts to enhance collaboration with its counterparts all around the world. And so far, it has joined the Judicial Insolvency Network and concluded MOUs with several foreign jurisdictions. And I want to say that the Hanjin insolvency case presented the Korean judiciary with an important opportunity to refine its cross-border insolvency system. And this may have led Korea to be ranked 5th in resolving insolvency-related issues amongst 190 countries around the world, as set out in the World Bank's Doing Business Report of 2018. I hope this talk helped you to better understand Korean law in practice, and hopefully this sheds some light to the cross-border insolvency issues between mainland and Hong Kong. Thank you for listening.
Thank you very much, Judge Kim. Our next speaker is Mr. Luk Chan Ho, and his talk is on cross-border insolvency and restructuring cooperation between Hong Kong and mainland.
Yeah, good afternoon. Thank you for having me here. So it's an honor to talk about the cross-border insolvency arrangement or cooperation between Hong Kong and the mainland on this occasion, especially we are talking about one country, two systems. And the reason why cross-border insolvency is very important in this context is twofold. The first is that it completely highlights and accentuates the importance of one country, two systems. It shows how one country, two systems works. Secondly, the maturity of a legal system, in my view, is actually tested by its cross-border insolvency regime. This is what I mean, and based on what I see in practice. In a market economy, credit is inevitable. When credit is inevitable, bankruptcy is inevitable. When credit crosses borders, cross-border insolvency becomes inevitable. Now, insolvency is always about policy, because insolvency is always about how to manage a situation where you do not have enough assets to be distributed to different stakeholders. That means a priority is needed. Who gets paid first? Who gets paid second? Who gets paid last? So that is, in every country, a policy question. Each country would have its own policy. In China, we are talking about two systems. So each jurisdiction, each system would have its own policy. The policies would be different. The policies sometimes would be conflicting. So that's why when it comes to cross-border insolvency, the test would be your system. Does your system have the courage to recognize policies from a different system? So when I was at the World Bank assisting various developing countries in their insolvency law reform, when it comes to cross-border insolvency, the recognition to be given to foreign insolvency proceedings, even when I was in the UK, assisting the UK government on its implementation of the ancestral model law on cross-border insolvency, the question that came up all the time was whether we should have reciprocity. In other words, as Professor Wessels explained just now, whether recognition should be based on the fact that we would only recognize proceedings commenced in jurisdictions that would also recognize our proceedings. The thinking is, if there is reciprocity, there is some control in order to avoid a situation where we would recognize and assist policies that are totally different from ours. The straw man always make in comments is insolvency proceedings were commenced in Timbuktu. Would we recognize those proceedings? So that is why when a country uses or enacts its cross-border insolvency regime, the strength of the cross-border insolvency regime is almost a litmus test for the maturity of that legal system. Now, turning to the mainland and Hong Kong. The mainland has, prior to the SPC arrangement that Professor Wessels talked about just now, a primitive cross-border insolvency system based in Article 5 of the Enterprise Bankruptcy Law. And that is unsurprising because in the mainland, the bankruptcy law was only recently enacted in 2007. So the one country, two systems allow the cross-border insolvency regime to develop, resulting in the SPC opinion. Now, many people talk about the SPC opinion on the basis that it is an arrangement between Hong Kong and mainland to cooperate on cross-border insolvency. That description is actually incorrect, because that arrangement has nothing to do with any arrangement between Hong Kong and the mainland. That arrangement is simply based on a unilateral act on the part of the Supreme People's Court to give assistance and recognition to Hong Kong insolvency proceedings. Now, the significance is this. It highlights two things. It highlights the confidence that the SPC has in relation to the Hong Kong system. Because as I mentioned, when recognizing and assisting foreign insolvency proceedings, the recognizing jurisdiction always considers, would I be risking myself in recognizing proceedings from a different jurisdiction? So when the SPC decides that the mainland courts could recognize Hong Kong insolvency proceedings, that is a vote of confidence in the Hong Kong insolvency system. The second thing to highlight, as I mentioned, is that it is a unilateral act on the part of the SPC. Now, you may ask, why is that? Well, why is the SPC suddenly able to do that? Why is it not insisting on reciprocity? And the answer lies in how the Hong Kong court has been treating cross-border insolvency. You can imagine a situation where in fact, the mainland courts did ask when we were in the process of doing the regime. They asked, how does the Hong Kong court treat insolvency proceedings commenced outside Hong Kong? Would the Hong Kong court recognize and assist mainland insolvency proceedings? So they asked those questions. And the answer we could give is that, well, the Hong Kong court does not have a statute that says we would recognize proceedings commenced outside Hong Kong. But our case law does. And we could show our mainland counterparts the Hong Kong cases. Now, it's good that Judge Harris is in the audience, and I can say with full confidence, and this is, you can check the public record, that Judge Harris has single-handedly reformed our cross-border insolvency regime in Hong Kong. And in fact, it is precisely because we have cases, in fact, decided by Judge Harris, that recognize mainland insolvency proceedings, that the SPC could say to their stakeholders that we do not need to have a signed arrangement, the arrangement of the sort that you would have heard about in prior sessions today, that an arrangement that was signed by both Hong Kong and the mainland saying, you would do this, I would do that. There's no need for that, because what we say to them is, the SPs on the mainland part, you could recognize Hong Kong insolvency proceedings. On the Hong Kong side, you do not need to have a signed arrangement from the Hong Kong government. That is because our Hong Kong cases already give recognition and assistance to insolvency proceedings commenced in the mainland. So in other words, this cross-border insolvency regime that we see now is a manifestation of confidence given by the mainland courts in the Hong Kong systems, and also the result of actual practical cooperation granted by the Hong Kong courts to insolvency proceedings commenced outside Hong Kong. Now, let me now turn to the cases that show what I mean in terms of the practical assistance. I turn to the first two cases first, namely CEFC and Shenzhen average. Now, those cases were the cornerstone of Hong Kong mainland insolvency cooperation. Because without those two cases, there wouldn't be, I can guarantee you, there wouldn't be the SPC opinion. Because it is those two cases that reassured the mainland counterparts that there's nothing to fear about cross-border insolvency. And those two cases show in a cross-border insolvency cooperation situation, what assistance you can grant and the benefits that you could get from the assistance to be granted. I'll just summarize the cases very briefly in view of the time. Now, in the CEFC case, what happened was there was a Shanghai liquidation. Upon being appointed, the Shanghai liquidators found out that one creditor has got a judgment against the company already in Hong Kong under an agreement known as a Keep Well Agreement. The judgment debt, as I recall, was about 79 million euros. The creditor was about to obtain a garnishee order absolute against the debtors, i.e. CEFC's assets in Hong Kong. The Shanghai liquidators, upon being appointed, found that out. Or of course, all this, of course, the judgment, everything, the application for the garnishee order was obtained prior to the appointment of the Shanghai liquidators. So when they found out, they quickly came to Hong Kong. I was involved to apply for recognition in Hong Kong in order to stop the garnishee order. Because if you do not stop the garnishee order, the money in Hong Kong would be used to pay that particular creditor only. So therefore, it would be very unfair to all other creditors. And Judge Harris, for the first time ever in Hong Kong, granted recognition and assistance to the Shanghai liquidators. And then so we stopped the garnishee order absolute from being made. And then the second case shows why cross-border insolvency is needed. In that case, liquidators were appointed in Shenzhen. The Shenzhen liquidators found out that the company had subsidiaries in Hong Kong. The subsidiaries had bank accounts in Hong Kong. However, the director of the Shenzhen company and its subsidiaries in Hong Kong was the same person. And he'd been arrested. And therefore, the subsidiaries in Hong Kong no longer had any management. Without any management, the subsidiaries would not be able to get the money out of the Hong Kong bank accounts. So therefore, there was a practical need for the Shenzhen liquidators to be able to control the Hong Kong subsidiaries, to manage its affairs, and in particular, to get the money out of the bank account. So that's why they came to Hong Kong to apply for recognition, and I was involved as well. Again, Judge Harris granted recognition to the Shenzhen liquidators and therefore allow the liquidators to control their subsidiaries and take money out of the bank accounts in Hong Kong. So those two cases show the SPC how cross-border insolvency and cross-border recognition and assistance would work. Then basically those two cases then led to the confidence given by the SPC in the Hong Kong system that then led to the opinion that Professor Vessels talked about just now. And then after that, in 2021, we had the HNA case and the Noxie Capital case, or sometimes known as the Peking University founder case. Now, those two cases are extremely important, which I will talk about later. HNA is the first time ever where the Hong Kong court recognized and assisted mainland reorganization proceedings. The prior two cases concerned mainland liquidation. HNA was the first ever recognition of mainland reorganization proceeding. And one of the assistants relief granted there was that actions in Hong Kong against the company, HNA, would be stayed, which is a typical insolvency assistance. The second case, again, concerns one is known as the keep well arrangement. The facts are fairly complex, but I'll just, for present purposes, all you need to know is the following. Peking University has signed an agreement known as a keep well agreement in order to raise funds through Hong Kong and offshore jurisdictions. Peking University became insolvent and went into and became subject to mainland reorganization proceedings. The keep well agreement was governed by English law and is subject to the exclusive jurisdiction of the Hong Kong court. The beneficiary of the keep well agreement, i.e. the creditor, sued the company, i.e. Peking U, in Hong Kong. Peking U, as I mentioned, has gone into mainland reorganization proceedings. The mainland administrators then came to Hong Kong to apply for recognition and assistance using the example of HNA that I just mentioned. They say what they say is very simple. We are mainland administrators. We have a mainland reorganization proceeding. You have Hong Kong court. You have recognized these proceedings before. So please recognize us. Please assist us. Assist us by staying the action in Hong Kong against us. The Hong Kong court, again, this is Mr. Justice Harris. That's why I say Judge Harris has basically single-handedly reformed and developed the Hong Kong cross-border insolvency system. The Hong Kong court said, fine, we recognize your proceedings, we would assist you, we would stay actions in Hong Kong, but we would not stay this particular action. Because we respect our common law system, which is you need to show very good reason before we depart from exclusive jurisdiction clauses. So in this case, we will not stay it. And we cannot see any good reason for staying it. What the administrators say is there is a very good reason for staying it. Because fine, you allow the action here to proceed. You allow a judgment to be obtained. Let's assume the plaintiffs win. In fact, I echo the plaintiffs. You assume that the plaintiffs win. You get a judgment against us, Peking U. But our proceedings are based on the mainland. Whatever judgment you can get is going to be useless. The Beijing court will simply ignore what you say. This is the argument made. In the end, the Hong Kong court's conclusion is that that argument doesn't sound right. We do not believe that the Beijing court would totally ignore the Hong Kong court judgment on English law issues. In a one country, two system situation, who do you think, Beijing court or Hong Kong court, would be better placed to determine issues of English law? Would it make sense for the Beijing court to say, Hong Kong court, you have decided issues of English law, we will ignore. But in order to determine the particular issue which is governed by English law, we would take expert evidence from different experts. But isn't it the answer that the best expert evidence you could get is actually the Hong Kong court judgment? And that's the reason that the Hong Kong court accepted. The Hong Kong court therefore did not stay the action. Now, what is interesting is that subsequently there was a letter written by the Beijing court to the administrators to be shown to the Hong Kong court. The Beijing court said, we look forward to more cooperation with Hong Kong. if the trial proceeds. Now, therefore, what is interesting for our topic, for the purposes of our topic, is that cross-border insolvency is not just about recognition of proceedings, assistance to be granted to office holders in the form described by the SPC in the arrangement. It is also about how to manage the actual cases, the actual facts, actual problems before the court. The PUFG case is a perfect example. What the Hong Kong court does, in my view, is the best illustration of cross-border insolvency cooperation. We would recognize to the fullest and assist to the fullest mainland insolvency proceedings. Now, the mainland administrators have their own domestic reorganization to manage. They, for example, need to determine whether the claims under the Cuban agreements are valid. They are governed by English law. In the end, in due course, the mainland court, i.e. the Beijing court, would have to grapple with this question. I need to consider whether these claims under English law are valid or not. So, the Hong Kong court, in the one country, two systems situation, would say, well, in fact, I'm helping by not allowing the actions to be stopped, by not allowing the proceedings to be transferred to Beijing for determination. The Hong Kong court is actually helping the Beijing court to determine English law issues. So that, I think, although that was not stated clearly in the letter from the Beijing court, that must be, I guess, the reason why the Beijing court said in the letter, saying that they look forward to more cooperation with Hong Kong. So this is yet another, the most practical example of how cross-border insolvency works, and why one country, two systems would work to the best advantage of the whole Chinese ecological system. I'll just mention briefly how the mainland courts have been helping Hong Kong insolvency proceedings under the SPC arrangement. There have been 4 cases. I'm involved actually in 3 of them. So what we need in order to trigger potential assistance in the mainland is that you need a letter of request from the Hong Kong court to be sent to the mainland courts. And there are only 3 cities that are relevant, i.e. Shenzhen, Xiamen, and Shanghai, for the courts there to determine whether assistance should be granted or not. So far, 4 letters of request have been sent. All of them were sent by George Harris. 3 letters have been sent to the Shenzhen court. 1 letter to the Shanghai court. Xiamen hasn't happened yet. Out of the 3 letters of request to the Shenzhen court, 1 has resulted in an actual recognition order. That's Samsung paper. That case was fairly easy. It was essentially Hong Kong liquidator saying we wanted assistance in the mainland in order to control various assets in the mainland, including various receivables in the mainland, and also in that case, a flat in Beijing. In Osner Water, it was similar. There was a letter of request to the Shanghai court. There, the liquidators appointed in Hong Kong found out that some of their assets have been misused by the former management in Shanghai. So this is a water company, so water machine company. So the Hong Kong liquidators found out that the old management had been using the same technology, almost the same name, same logo in a different business in Shanghai. So that's why they wanted to stop it. Zhao Heng was a bit more complicated. Again, it was related to investigation in the mainland. Hong Kong freshwater was very similar. It was a situation where the Hong Kong liquidators wanted to take part in proceedings in the mainland against a company in order to protect the company's assets. So what we see at the moment is that the development is ongoing. What we hope is that there will be more cases, more complicated cases, such as the Peking U case, allowing the mainland court to see how cross-border insolvency works, so that the mainland courts would have even more confidence in the practical operation of cross-border insolvency and cross-border cooperation. So to conclude, so what I would say is Professor Wessels has very clearly set out the various types of various models, how we could use to improve the systems further. Regardless of what model we use, ultimately it depends on the actual individual judge's approach to all of this. In Hong Kong, we have been very practical in allowing assistance to happen, despite the complete lack of legislation. In the mainland, if the same approach could be taken, this is how we would show how the systems, how the two systems we have here are truly mature insolvency systems. Thank you very much.
Thank you, Mr. Ho. I now invite our last speaker, Professor Charles Booth, and his talk is on cross-border insolvency cooperation between mainland and Hong Kong, a proposal to extend cooperation to personal insolvency proceeding involving Shenzhen in Hong Kong.
Hello, everyone. It's good to be back at Hong Kong U. It's been a number of years, and I'm glad that my presentation is last because it follows nicely on the framework laid out by Professor Wessels, and then the presentation we just heard that really lays the backdrop for what I want to talk about, and that is to extend the current arrangement under the SPC agreement to personal insolvency, primarily to bring in what Professor Wessels was talking about with SMEs, small and medium-sized enterprises and even micro enterprises. So at one level, it might seem, well, after we just heard about all these big complicated cases, why do we want to waste time on all these small cases? What I'd like to do is to give a little background to show why I think this is the time to move in that direction, and to show to you that that is exactly what is happening throughout Asia. There's a renewed focus on SMEs. I was living in Hong Kong when the '97 Asian financial crisis hit. A year before, Hong Kong actually had the opportunity to be the first jurisdiction in the world to sign on to the Insolvency model law. And they passed at that time thinking that it was premature. And as we fast forward to the present, we can see how much has developed. And as we've heard, because Hong Kong had not signed on to the model law, that is the reason why we need so many court judgments, because it's those court judgments that sets out the framework in the Hong Kong law that we did not have previously, because we did not sign on to the model law. So why personal insolvency? Well, if you look back at the time of the Asian financial crisis, in Asia, the focus was clearly on corporate reorganization. At that time, Asia was focused on liquidation models. There were few jurisdictions where restructuring could occur efficiently, and if so, even fewer where it could occur under the formal law. Over the next 2 decades, we saw massive law reform throughout the region that improved the framework and the results in many, many Asian countries. But even at that time, there was still a general ignoring of small and medium-sized enterprises. All of that changed with COVID. When COVID hit, it was very clear worldwide that it was the small enterprises that bore the brunt of the problems. And then many organizations started looking at the data. And in many Asian countries, the engine of growth is the small and medium-sized enterprise. In many countries, above 90% of new businesses are of this nature. It was also those enterprises that had a very, very difficult time getting funding from the governments when COVID hit. In many countries, much of that money went to the larger entities. So we see right now in Asia is a renewed focus on small and medium-sized enterprises. During COVID, Singapore and Australia both tinkered with their laws and brought in some temporary reforms to deal with problems, to streamline things along the lines of what Professor Vessels was talking about. It is very likely that those temporary measures might well become permanent. We see other jurisdictions like Myanmar, the Lao PDR, that did not have personal insolvency regulations or laws before enacting them. They're starting right now. The new Lao law came into operation not long ago. So against that backdrop, we said that within the region, with this focus on these smaller cases, that if Hong Kong and the mainland entered into an extension of the current process, it really would be a very good example for the rest of the region as to how to proceed in these cases. Now, a second point about why this is helpful, and this in some ways is the opposite of the point just made, is that these cases are much simpler. These are easier cases. Of course, personal bankruptcy law predates corporate insolvency law by many, many years. So the general ideas and terms are more easily understood. And I think what that would help with, if the extension of the agreement were made, is that you would get more case flow. We've seen that right now we have 4 cases. In these complicated cases, with the complexity of these cases, they come along infrequently. So when we take a look at Hong Kong and Shenzhen, they are perfectly placed side by side to have the possibility of greater case flow, of greater activity between the two jurisdictions. Now, here another point has to be made, and that is, well, will there be cases? Will there be personal insolvency cases? Now, why am I talking about Shenzhen now? Well, just recently, they enacted the regulations on personal bankruptcy. They're the first part of China to do so. The regulations came into effect about a year and a half ago in March of 21. So we are in the very, very early stages. But when one looks at the data on filings, one will see that with personal insolvency laws, unlike corporate insolvency laws, once that there is a sense that the discharge on an individual will work, you see a increase in the number of cases. Now, what do I mean by that? Well, unlike companies, which at the end of the day can be dissolved, individuals go on. So there has to be a mechanism for allowing an individual to get a fresh start and reemerge after insolvency and become a working member of society again. And I think there, Hong Kong is a very good example. Back in the day, before Hong Kong enacted amendments to its law, and this was in the 1990s, there were only a few hundred personal bankruptcy cases a year in Hong Kong, 200, 300, 400. And then when the new regime for bankruptcy law came into operation in 1998, we saw a dramatic increase. Within a few years, the number of cases had gone up to almost 27,000. That was back in 2002. That's a huge, huge increase. Previously, there was a sense that this old law with a discharge that was very difficult to obtain would be of any use to them. And then you see almost 27,000 people filing. Now, today, of course, the numbers are lower because what you see is that when you enact a new law, there's often an overhang at first. And then over time, you work off that overhang. But even right now, for the last decade in Hong Kong, you see between 6,000 and 10,000 cases a year. Ironically, this year, even in the midst of COVID, looks like it might be the lowest number in a decade. But even so, that will still be close to 6,000. So when one looks at what's happening in Shenzhen, the law has just been basically just been enacted, just come into operation. Talking to a judge from Shenzhen just over the last few days, I learned that there's roughly about 2,000 applications. Not, of course, that they've all gone forward, but 2,000 is a sizable number. That actually is a very significant number for a city with, depending how you define Greater Shenzhen, 15 to 20 million people. And that's on par with what we saw in Hong Kong. Now, of course, for a personal bankruptcy law to prove effective, individuals have to see that discharges will be granted. So there's a lag. So as cases get accepted, as individuals pass through that system, between 5 and 10 years from now, you will start seeing whether or not that process is accepted. Now, it's often been said that in Asia, that individuals will not file for bankruptcy because of the stigma, because of the shame. But my experience is that when you take a look at the development of consumer economies, really in every jurisdiction in Asia, when the funds were available to consumers, we've seen an increase in insolvency laws. And that is even true in jurisdictions like Japan, where historically you had a cash-based society. So that is sort of one factor focusing on the individuals. The other one has to do with entrepreneurs. And as I said, small businesses are the engine of growth. And that is also true in Shenzhen. There's a lot of innovation. There's a huge amount of investment of time and capital in technology. That is very, very risky. A lot of those ventures will not prove successful. A regime that focuses on finding a way for these small businessmen and businesswomen to move forward is very, very important. Now, the last point then is that we can take a look at the Shenzhen regulations. Hong Kong has its own personal bankruptcy law. What is interesting, if we want to think of it as an experiment, because my proposal is just for Hong Kong and Shenzhen, is we take a look at the traffic between those two jurisdictions. One, we have daily traffic. Two, even before COVID hit, we saw a lot of cross-border investment. Now with COVID, we've heard stories of individuals from Hong Kong moving to Shenzhen. I've seen other ones of individuals from Shenzhen wanting to come to Hong Kong. So individuals going back and forth. Oftentimes, there are homes either owned in both jurisdictions or rented in both jurisdictions. We know, of course, of many small businesses in Hong Kong that have assets in Shenzhen. So you basically have all these factors that could lead to case flow. And one of the points that Luc made is just so important. You want to build up confidence of each jurisdiction in the other jurisdiction's judgments. And what you need for that is to get the case flow. And my thinking is that with the area of bankruptcy, that we get there more quickly, that we could get more predictability, that we could get more efficiency. And because the cases are simpler, that it would then give us a framework that we could then apply to the larger, more complex cases. And I will leave it at that for now. Happy to have any questions answered later. Thank you.
Okay, thank you, Professor Booth. So we've had some very insightful talks from each of our four speakers on the panel just now. We'll now come to the Q&A session. So if anyone from the audience has any comments or any questions for members of the panel, then please raise your hand and you can speak. Thank you.
I have a question about the implications of those pioneering cases for the possible. The Chinese property development industry is in trouble. A lot of those companies have issued debts or bonds in Hong Kong or listed their shares in Hong Kong. Now, if the lenders of those companies file for bankruptcy petition in Hong Kong, the recent development the speakers have just described, what would be the implication for the success of those potential petitions? Or maybe they're already going on, I don't know. But is it possible that those cases we just talked about will have implications for the resolution of foreseeable wave of bankruptcy petition for the property development industry? Thanks.
Yeah. Does anyone get Professor Booth here?
It's more of a formal record of in every insolvency case, one, whether there's property located outside Hong Kong, and two, where it is. And then given the arrangement that exists now with the mainland, to even separate it into city by city. Because I think one thing that could come from that is that, especially with the problems in the property market, you might find that you have more cases in one city than another city, and then almost come up with an extension of this agreement just to that city for dealing with real property. And part of my thinking with looking into the SMEs is starting off there smaller, but what you're talking about is a mammoth problem, because in many of these cases, you're dealing with large property assets, but of course, one of the difficulties is they're not completed. So in terms of actually, liquidating and making and getting money out is very difficult. And then secondly, for carrying on, you have the issues with how new money comes into the system. But I think you've put your finger on an area where you'll see a lot of activity. Although I think, given the nature of it, what we just heard from the presentation on larger companies, that's where it's going to be, because you're dealing with some very large numbers and many developments.
There are two different angles. The first is you mentioned the petitions in Hong Kong. What are the implications if winding up orders are made in Hong Kong? But before we get there, we have to think about two scenarios. Why is it that the Hong Kong court would like to make a winding up order in view of the cross-border insolvency cases? Because let's imagine you make a winding up order. The liquidators appointed in Hong Kong will want to get to the mainland using the arrangement and say, I now represent the company. I want to control the assets. This brings up precisely the policy issue that I was just talking about. The mainland court would be facing a situation where liquidators from Hong Kong, acting like barbarians, wanting to control mainland companies, wanting to control assets of the company, maybe firing people, maybe stopping the projects in half-built projects, just doing a fire sale in order to repatriate assets back to Hong Kong to pay the creditors. Now, this brings up a policy question. Would the mainland court allow that? Because this brings up a lot of potential social instability. I think that issue remains unresolved because it's never happened. But the idea that recognizing Hong Kong proceedings would lead to unemployment would lead to operations being shut down has always been part of the discussion, or the reluctance, potential reluctance of recognition, which is understandable. That's why I say cross-border insolvency regime really is the litmus test of the maturity of a legal system. Now, we don't have to get there if the Hong Kong courts behave in a sensible way. You might, the companies would say, well, this arrangement actually helped what we are trying to do. What we are facing is not, I'm speaking generally. The companies will say, well, what we are facing is not the result of misconduct or personal irresponsibility. What is happening is the result of the macroeconomic conditions. What is happening is a system-wide issue. Each company's problem is different, but it's a system-wide issue. Property prices falling, lacking demand, and so on. So what you need to do, what the companies can say to the Hong Kong court is, what you need to do is not to make a winding up order. Allow us to do a restructuring, knowing the arrangement that is now in place. Our restructuring can potentially be recognized in the mainland. Therefore, with also the mainland restructuring that we know is going on, because I've been helping a lot of these companies. The mainland operational restructuring and that restructuring can be combined with the Hong Kong restructuring, which can be recognized in the mainland, thereby achieving a comprehensive restructuring. So therefore, the arrangement actually can be used to avoid the situation that you just described. How would what would be the implications if the Hong Kong court makes a winding up order? I think the answer is that with this arrangement, there is more incentive for the Hong Kong court to behave in a sensible way and not to make a winding up order unless the circumstances really justify a liquidation.
Okay, I'm just mindful of the time, but maybe we'll just take one more question if anyone has any.
The arrangements that have been entered into between the Secretary for Justice and the Supreme People's Court should be thought about. I think that's really the big issue. How do we think about what's been going on there? The reason why, well, let me start here. As Luke has already explained, the opinion that the SPC has produced is not an agreement, a protocol, or an arrangement with the Hong Kong government or the Hong Kong judiciary. It's an internal document, and it's advice directed to 3 intermediate people's courts. I say 3 intermediate people's courts because it relates to the signed minutes of meeting that were made back in May of last year between the Secretary for Justice and the Supreme People's Court. And that only extends to 3 intermediate people's courts. And I was asking my colleague on my left, Judge Wang Shenzhen, how many intermediate people's courts there are in the country. And we took a few minutes to calculate this, but we think it's approaching 300. So what we're talking about is not an arrangement between the mainland and Hong Kong. We're talking about something much narrower. Why are we talking about something much narrower? Well, in exploring that particular question, you begin to understand why a lot of the matters that Bob Wessel has referred to as things we might think about in the future are not included in what's been done so far. They're not excluded. They're not the result of people failing to identify them or identifying them, discussing them and dismissing them. It's simply that the kind of considerations that people are taking into account, mainly in the mainland, are very, very general. And they come to a consideration of the issues that we're talking about from a standpoint which gives considerable weight to the different socio-economic considerations which courts in the mainland operate under. What they're concerned about, what drives them, what allows them to agree certain things are dramatically different from what influences me or what will influence the Department of Justice in Hong Kong when it's carrying out informed discussions on these matters with the SPC. And when I'm producing judgments, certainly the earlier judgments, I'm very mindful of that. So the first two judgments that Luke was referring to resulted from applications which were made specifically to test whether what I had been explaining to the Supreme Court at seminars and meetings that I had in the mainland was in fact correct. And when it turned out that what I'd been telling them I would anticipate would happen, that reassured them that there was reciprocity and they could trust what we were saying. So it's one small but important step forward. So at the moment and for the foreseeable future, what we're really doing is allowing the mainland, and this is relevant to the point that Luke was making, that cross-border insolvency involves a consideration by different jurisdictions of the extent to which they're going to recognize another jurisdiction's policies. The mainland exploring how the policies we have in Hong Kong can be reconciled with the policies that they have, which are significantly different, and how, in terms of these very broad, shapeless issues, we can cooperate. And it's only when the mainland is confident that the arrangement seems to be working in a way which they find acceptable between the more sophisticated intermediate people's courts in the mainland, which have the benefit of having judges like Judge Wang in them, that they will begin to extend it to other intermediate people's courts. And once they're confident that at this relatively low, unsophisticated level of cooperation, it's working, will we get to the stage where we'll be able to think about the more sophisticated kind of protocols and models that academics are inclined to think of. So I think in understanding where we are and where we're going to be in the coming years, that's what one really needs to be mindful of. And I'm not going to go into details about some of this because it's confidential. If you're familiar with the way the courts in the mainland operate, the idea of getting things agreed in a week, dealing with anything sophisticated, just seems silly because it just does not work like that. So, for example, the first two applications we had for recognition here, the second one was meant to be the first one. It was the second one because some people might think that the judge who was meant to be dealing with it just sat on the file worrying about it for months because they had general concerns which they were having difficulty reconciling. They weren't concerned with detailed rules. They weren't concerned with law because they didn't have it. They had much more basic considerations which were influencing their approach to things. So in trying to understand where we are and where we're going to be in the coming years, I think that's really what you need to fully appreciate.
Thank you, Judge Havers, for those very helpful comments. So I think we'll wrap up the cross-border insolvency panel now. And so thank you again for each of our speakers. It's been very informative and illuminating. Thank you.